person has a right to use the public roads for private gain, but this is a special, extraordinary privilege the state may grant or withhold. With these requirements, when these requirements are placed upon the private person's travel, it impairs the right of the sovereign and is considered a color of law. As a matter of fact, the police officer can only pull you over if he has evidence that you've committed a crime. The authority can only charge you with a crime based on a valid cause of action. In order for any cause of action to be valid, there are three elements that must exist to establish corpus delicti, the actual body of the crime. Speeding may be a charge, but does not establish corpus delicti. In order for a cause of action to have validity, the three essential elements are alleged violation of legal right, alleged damage or injury, or redressability by the court. If these three elements do not exist, the case has no standing, the cause of action is invalid, there is no corpus delicti, and the court does not have jurisdiction to entertain or hear the case. Clifford v. Superior Court. Without standing, there is no actual or justicable controversy. The courts will not entertain such cases. The Supreme Court has also ruled in favor of the wording of the Declaration of Independence regarding the judicial power of the court, and reinforced the point that the reason men form governments in the first place is to secure the blessings of life, liberty, and the pursuit of happiness. The court's entire jurisdiction is limited to protecting the life, liberty, and property of the American people, quoting the Supreme Court, to adjudicate upon and protect the rights and interests of the individual citizens, and to that end, to construe and apply the laws, is the peculiar province of the judicial department. The judicial power is the power to hear and determine those matters which affect the life, liberty, or property of the citizens of the state. City of Scapulet versus Lane, Nash v. Brooks. The impressive array of cases the Supreme Court has held deciding the right to travel are as follows. The claim and exercise of a constitutional right cannot be converted into a crime. Miller v. United States. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Snare v. Cullen. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of the public, and the individual cannot be rightfully deprived. Chicago Motor Coach v. Chicago. Laguerre v. Chicago, Boone v. Clark. The right of the citizen to travel upon the public highways and to transport his property thereon, either by horse-drawn carriage or by automobile, is not a mere privilege which a city can prohibit or permit at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. We can see that the right to travel is clearly established. So where is it that the perception that driving is always and only a licensed privilege come from? It's quoting the Supreme Court again. But while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of the highways either in whole or in part as a place for private gain. For the latter purpose, no person has a vested right to use the highways of the state. It is a privilege or a license which the legislature may grant or withhold at its discretion. State v. Johnson, Cummins v. Holmes, in many cases too numerous to mention. I must cover the tendency of police to impound cars that have no plates, registration, inspection, etc. The primary issue here is that the police officer does not have the authority to take your car away from you. As shown in the Fifth Amendment, you cannot be deprived of life, liberty, or any property without due process of law. Unless the police officer is judge, jury, and executioner, your little roadside chat does not constitute due process of law. You cannot be deprived of any right, life, liberty, or any piece of property absent a conviction by a jury of your peers. That is due process of law. Exercising the right to travel, unencumbered by government, bureaucratic regulation, and permission, cannot be converted into a crime. You are not subject to regulation. You are not a subject of government. You are government. No body of crime can be proven as a result of the sovereign not subjecting himself to the regulation of license plates, registration, inspection, or even insurance. These matters do not involve the allegations of damage or injury, or violation of the legal right. They have no standing in the courtroom, and there is no case. Your property cannot be taken. If it has been taken against your will, in violation of due process of law, you have legal recourse against the person or government seizing your property illegally. The illegal seizure of property without due process of law does establish corpus delicti, as it alleges violation of your legal right to not be deprived of property without due process of law. The damage or injury is the deprivation of your property, and the assessment of impounding fees, most likely. The local court has the jurisdiction to hear these matters. The police have the oath of upholding the Constitution. The county sheriff is the supreme authority of the common law, especially here in New York. The sheriff's main job is to protect the people from the color of law. The county sheriff is the position of supreme authority equal to the president within the county. All public servants have taken an oath to uphold and defend the Constitution. The Constitution is the law of the land, the common law. If your property is illegally seized, or if you are illegally arrested for not committing any crime, the writ of habeas corpus is the answer. The writ is to be granted whenever a person is in actual confinement, committed or detained as aforesaid, either for a criminal charge or as in Pennsylvania and here in New York, in all cases where he is confined or restrained of his liberty under any color or pretense whatsoever. You have legal recourse against those who violate your rights. The common misconception in America today is that the free market system is failing. Again, the conventional wisdom fails us. We have not been operating on the free market system since 1913. We are experiencing the same problem with our economy today that we did in May to September of 1787. The economy was the driving focus of the Constitution that we have today. The colonies or states under the Articles of Confederation began printing their own paper currencies, which became rapidly useless through inflation. The great American struggle through history has not been against any invading country or band of countries, but against the establishment of the central bank. In 1913, the Federal Reserve Bank was established as the country's central bank, and within 20 years, this bank caused the greatest depression to hit America, completely bankrupting the country and prompting the first ever gold seizure. Prior to 1913, money in America was very different from what it is today. Each certificate of money was a representation of physical gold that could be redeemed upon by the demander. Redeemed upon demand by the bearer at any time at the United States Treasury. The language on the bills, for example, said, "This certifies that $10 in gold coin have been deposited at the United States Treasury and is redeemable by the bearer upon demand at any time." These certificates were not the money themselves. They were a representation of the money. These are what we know as notes. Today, the money we have is not redeemable anywhere in gold or silver, nor payable in anything to the bearer upon demand. The Federal Reserve Bank is not federal. It is privately held in an international bank. The Federal Reserve holds no reserves, it just prints money. And it does not secure the assets of the American people, so it's not even a bank. A three-word name in which all three are complete fantasy and fabrication. When Congress was charged with regulating the country's money, it was not charged to micromanage it, but to keep it regulated. To ensure that a dollar was a standard weight of silver or gold, identified by Alexander Hamilton, was 371¼ grains of pure silver. It's pretty much close to 1 ounce of silver. It takes over 15 Federal Reserve dollars to buy one legal dollar today. Congress was never given the authority to outsource its responsibility of regulating the money, especially not to a private international bank. This is why I use the acronym FRAUDS when referring to Federal Reserve Accounting Unit dollars. This system, which needs constant stimulation to survive, is the reason we have a nearly 100% disposable economy today. You trade true wealth for a product that was designed to destroy itself. Value is squandered in this way. Do you know the saying, "They don't build them like they used to"? This is literal in every sense. We're on the pinnacle of state-of-the-art technology, but as we advance, everything is designed to be replaced instead of being built to last. Money itself came about as a sole means of preserving wealth. If you were a farmer and grew 10,000 heads of lettuce, but only needed 1,000 yourself, you would trade the perishable lettuce for a non-perishable physical commodity that would maintain value. Gold and silver have maintained their value for thousands of years and became the standard of the preservation of wealth. Our money today is not money. It is evidence of debt. We wonder why the economy is failing when this system was designed to implode and leave the international banks with ownership of the property. The entire system is the most monumental fraudulent scam in the history of mankind. The most intriguing aspect is that this is not a new phenomenon. This is the method by which great nations